Senator Lee.
Mr. Chairman, I too have concerns with this nomination. I've spoken more than on a few occasions about various nominees, people nominated to the courts by President Biden. And in some instances, I've raised concerns in particular about their qualifications. We've had some who have either refused to answer, but more commonly proven unable to answer really basic questions about elementary principles of civil procedure, the Sixth Amendment, the rules of evidence, and even the Constitution. It's concerning on a number of levels. Look, it's not as though there were a shortage of lawyers in America. It's not as though there were a shortage of well-qualified lawyers in America, people who have practiced before federal courts routinely through the course of their profession. Nor is it difficult to find lawyers who are well-qualified based on many years of practice before various federal courts, including in many instances the court to which they've been nominated, who are themselves ideologically compatible with this administration. Legal academia in the United States leans a particular direction, and it's not toward conservatism. It's not hard to find people who are compatible with this administration's approach to statutory construction, to jurisprudence as a whole, who are also well qualified. That's why I find some of this confusing. And of all the nominees who couldn't answer the most basic of constitutional questions, Judge Belkengren may well take the cake. Again, when asked by Senator John Kennedy, she admitted that she wasn't familiar with Article 5 of the Constitution or with Article 2 of the Constitution. If I'm not mistaken, she said something to the effect that, I haven't litigated over those things. Well, most people haven't litigated over them. They're essential to understand nonetheless. They're critical parts of the Constitution. And it's not as though the Constitution contains that many articles. It's stunning that she couldn't even comment on the subject matter of those foundational constitutional provisions. One doesn't have to have litigated on those things to know what they are and to be expected to know what they are. Look, I wouldn't hire a law clerk who couldn't answer those basic questions. And so I certainly can't fathom supporting a federal judicial nominee for a lifetime appointment as a federal judge who can't. Now, let's stop and remember here for a minute what a federal judge is and does. It's not just that it's a lifetime appointment. It's a lifetime appointment for a job that will impact people's lives, livelihoods, freedom, whether they go to prison, whether they win or whether they lose, on a wide variety of topics. Federal judges are required to be generalists in a very real, traditional sense. They're required to have a pretty significant, deep understanding of the federal rules of civil procedure and the federal rules of criminal procedure, the federal rules of evidence, and they need to know their way around the U.S. Code, and certainly they need to be familiar with the basic elements of the U.S. Constitution. Anyone who's ever practiced before any court, especially the federal courts, as I have, has experienced what it's like to appear before a judge who is less qualified than other judges. And to describe it as a painful experience to everyone involved, especially those represented by the lawyer, is a vast, vast understatement. So we're not just being petty here in raising this concern. This will have real-world implications that can be very painful, that can be very devastating. Most people don't want their case handled, tried, adjudicated by an inexperienced judge any more than they would want to get a root canal performed by someone who doesn't know how to practice dentistry. And so this really is concerning. I know this administration can do better, and I expect this administration to do better. There is no shortage of people capable of doing this. There's no shortage of nominees who know what Article 2 and Article 5 of the Constitution are. There's no shortage of nominees, even who share the president's worldview, who haven't tried publicly to shame a 15-year-old victim of sexual abuse. There just isn't. You don't have to do this. Now, as to the suggestion that I'm sure it's coming because it's come every time we've raised concerns in the past. Suggestion is going to be, well, you don't raise these concerns when a Republican president is in the White House. That's not true. We did. I personally voted against a number of them who weren't qualified, who had issues. I personally, on occasion, would even reach out to the White House and said, what are you doing? This doesn't work. I'd urge each of you to do the same. Just think of the litigants in your respective states and across America who will be negatively impacted by someone who not only doesn't know their way around the courtroom, but doesn't understand the law. We can do better, and I expect the White House to do so.
Anyone else seek recognition? Senator